You're listening to the Real Estate Way to Wealth and Freedom podcast, episode 15.
Welcome to the Real Estate Way to Wealth and Freedom podcast with Jacob Ayers, providing actionable content to help you along your journey to financial freedom through real estate investing. As the premier asset class, real estate has helped ordinary people just like you amass fortunes. The benefits of passive income from real estate investing will allow you to live a life you want. And now your host, entrepreneur, real estate investor, and apartment deal syndicator, Jacob Ayers.
Hi, and welcome to the Real Estate Way to Wealth and Freedom podcast. I'm your host, Jacob Ayers. Today we're going to be discussing private offerings of securities with Stephen Rinaldi. Stephen owns a law firm in Maryland where he concentrates on business law matters and intellectual property matters since 2005. Prior to 2005, he was a software licensing attorney for Mercury Interactive. He also was the Associate General Counsel of the American Bankers Association and was responsible for all business agreements for a $30 million a year division of the association. Stephen specializes in private offerings of securities for real estate. Today I welcome on the show Stephen. Stephen, thanks for coming on. Today we're talking about raising money and what is required to do so. But first, can you tell us a little bit about yourself?
Okay, great. I'm Steve Rinaldi. I am a business and securities law attorney in Bethesda, Maryland. I'm admitted in D.C., Maryland, and Pennsylvania, but I've been handling private offerings of securities in virtually all 50 states since 1991. That includes but not limited to real estate syndications. And the services I provide include obviously structuring the transaction, forming the Delaware Limited Liability Company, writing its operating agreement, writing the private placement memorandum, and filing Form D with both the SEC and every state in which you have investors.
Hey, yeah, great. Thanks, Steve. So, talking about private placement memorandums, could you talk a little bit about what that entails? Because it was something I learned as I was going in my first process, and it was kind of all news to me. So, could you talk a little bit about the audience and tell them exactly what a private placement memorandum is?
A private placement memorandum basically describes all of the critical terms of the investment, including obviously the property, property's location, rent roll, delinquencies, when the property was constructed, what significant repairs have been done to the property, what significant repairs do you anticipate being done after closing, how much money you're going to raise, what's the profit and loss split, what percentage of profits and losses go to the investors as opposed to you, the managing member, what other types of fees are you going to collect as a managing member. Acquisition fee, disposition fee, fees for managing the property. Obviously, there are about 15 pages of tax disclosures, a disclosure of your prior real estate history over the past 3 years, even if you haven't done any prior offerings. There's a lot of people get into it by doing a basically buy, fix, and flip. And then they have enough cash to get into the multifamily realm. So we'd be describing that in your prior history. Obviously, there are about 15 pages of risk factors, a description of the operating agreement, a description of the management's discussion and analysis of financial statements, like what other fundraising sources are necessary, such as obviously the mortgage, the interest rate and the term of repayment of the mortgage, and a whole bunch of other things. Bottom line is a private placement memorandum for real estate syndication is about a 90-page document. Sometimes it can get as low as 80 or 75 pages, but it's a very comprehensive document.
Wow.
And
yes.
It takes me about 3 weeks to write it.
So its purpose is really to lay out all of the details for the investors and describe the investment, the risks, and the plan for the property, really, right?
Yes.
Right, great. And is that private placement memorandum required if you're raising money from only accredited investors?
Yes and no.
Okay.
If you look at the exact text of Regulation D only requires a PPM to non-accredited investors. However, and it's a big however, the Securities Act of 1933 requires a disclosure of all material terms of the investment. So in reality, unless you've got an extremely, extremely wealthy accredited investor with reams of lawyers and accountants to do due diligence on his or her own, it virtually is required for accredited as well. If something goes wrong, you'd be setting yourself up for a huge anti-fraud lawsuit.
Okay, right. So, starting from the beginning, as a real estate syndicator, you go out and you start raising money from potential investors. Once you have those funds raised and you start your private placement memorandum, what other
Actually, before you get the funds raised, when you get the property under contract, because you can't take a check from anybody until you give them a PPM and an operating agreement.
Okay, so along with the PPM, what other procedures or processes are there from the real estate?
There's the structuring of the transaction. Do you want to fit it within the Rule 504 exemption, which exempts offerings of $5 million or less from registration, but you've got to comply with various state blue sky rules, which can vary from state to state, and I'm not a big fan of 504 offerings for that reason. You could structure it as a 506B offering, which basically allows you to solicit from 35 or fewer unaccredited investors, as well as an unlimited number of accredited, and you can raise an unlimited dollar amount. The concern with 506B is you cannot advertise. You could structure it as a 506C offering, which is an unlimited dollar amount to accredited investors only, and you can advertise. But the problem with 506C is it locks out friends and family. So there are all various pros and cons. I think for most syndicators, the better way to go is either 506B or a double offering, 506B to unaccredited and 506C to accredited.
And you can have two separate offerings like that for one.
Yes. I mean, obviously it's more expensive because you're writing 2 PPM, but you can do that.
So the most common for your everyday syndicator is the 506B, which you can offer to 35 or less unaccredited investors and unlimited accredited investors, but you just can't advertise. Could you talk a little bit about what the definition of advertising is according to the SEC? Because I know there's some kind of gray lines there.
Yeah. Websites are advertising. Radio and television is obviously advertising. Doing a podcast or any type of broadcast is obviously advertising. Meeting somebody at a RIA event and talking to them over the course of 2 or 3 or 4 months and getting to know them and then inviting them to join the syndication is not advertising.
Right, okay. That's I think really important. And what about family when you're talking about the 506C? Even if they are accredited, they can't be involved in the
Yes.
deal? Okay.
Yeah, at that point we'd be looking at 2 different offerings. 506B to family and friends, 506C to the accredited investors.
Okay. So backing up here, you get the deal under contract, and immediately what you should do is start that private placement memorandum. Determine what kind of offering you're going to go with, and with the help and consulting of you, we'd be able to identify that, and then start drafting that document, and then raising money. What's next?
Okay, after that, I get a draft private placement memorandum, draft operating agreement out to you, form the Delaware LLC, go through it, make the changes, get it finalized. Then at that point, we send the final operating agreement, final PPM, and the subscription agreement out to the prospective investors. They sign it and write a check. And you let me know the day you get your first money from an investor, and I have 15 days to file Form D with the SEC and in every state where the investors are located.
Okay. And why the Delaware LLC, Steve?
That's a good question. A lot of local real estate attorneys like to form the LLC right in that state because it's cheaper. There are a lot of problems associated with that, however. Delaware has an exclusive court system for business disputes. If you get in a dispute with your investors, the Delaware Court of Chancery will hear and decide the matter in 12 weeks. Almost no other state has that kind of system. So you're getting judges who are way more experienced in business law matters. And there's nothing wrong with the local judges. It's just that they're hearing domestic disputes, they're hearing criminal matters, and they're hearing auto accidents all day long. So, I mean, they're fantastic on the rules of evidence, the rules of civil and criminal procedure. You want them to decipher provisions of an operating agreement, and they're immediately going to run and want to appoint a magistrate. It's not their thing. And obviously with the life or death matter concerning some family law and criminal law issues, you're going to get a lot of postponements and continuations. An upset investor over $50,000 or $100,000 is not as serious a matter as a restraining order at all. And very few judges would go the other way around. Delaware is a specialized court. The business disputes go to the Court of Chancery. No other state can deliver that. The second reason is what I call lawyers' laziness. Delaware is the most established body of corporate law and LLC law. If someone asks me a question, I can give you a pretty good answer based on existing Delaware cases. You're out in Oklahoma or wherever, there may not be a case on point. You're going to get an answer, well, we don't know, but Delaware would say this. That's the second reason. The third reason is some states are what we call foreclosure states, particularly Maryland, Virginia, Illinois. Creditors, your general personal creditors like your Amex or Visa, etc., if they don't think you're going to be able to pay them at the end of the month, they got a right to go into court and foreclose on the economic interest of your LLC membership units. Now all of a sudden the investing members are in your syndication are, for economic purposes, are Visa, MasterCard, Macy's, Nordstrom's, whoever, not who you intended.
Right.
Delaware does not allow foreclosure, neither does Nevada. So you run that risk there where people may say, hey, you may all of a sudden find a bunch of investing members who may have limited voting rights, but they do have a right to vote to sell the property. And the economic interest is held by the credit card companies and the retail stores, et cetera, and they're going to want their money. So now all of a sudden you got them in there pressuring you to sell as a managing member when your exit strategy may have been 5 years. Now they want 2 or 3 year exit strategy. You got different people on the bus. So I would not recommend setting up a local LLC, particularly in a foreclosure state, because you have no idea what your investing members' credit situations are or aren't. Just because someone can write you a check for $50,000 doesn't mean they don't owe Amex $100,000.
Good point. So the LLC that we're going to establish in Delaware and register in Delaware is the controlling entity that owns the property, right?
The LLC is a Delaware entity. It can establish series. Delaware and 14 other states allow series, such that the debts, profits, and liabilities of each series do not go up to the main LLC, nor do they go over to any other LLC. So what we usually do is establish one master LLC, establish a series for a particular fundraising effort, and then that series controls a local LLC, which owns the property. The local LLC is just basically a cash-in, cash-out entity. It collects the rent, it repairs the roofs, it paves the parking lot, pays the utilities at the end of the month, and then distributes everything up to the series to distribute it to the investors in the main LLC. That way, if somebody slips and falls on the property, they're only suing the local LLC, and the local LLC only has enough cash in to pay the bills at the end of the month.
Right, okay. Yeah, that makes sense. Okay, so now that we've set up our LLC, you have to file a Form D. Can you talk about what that is?
Form D is about a 4-page form that's filed electronically with the SEC, and unfortunately many states like Maryland are still paper file. So what you do is you file it with the SEC. I get the electronic acknowledgement back that it's been accepted. I then type one out, print that typed version out, along with a copy of the acknowledgement from the SEC, and mail it to each state securities agency in which there are investors, along with a check. Some states, like Delaware and Florida, there's not even any filing of the Form D. Others, like New York, charge $800. The bulk of the states I've seen range between $200 and $400.
And you have to have a Form D for every state that you have an investment
Yes.
from, is that right?
Yes, and New York has additional filings as well.
Okay. All right, so depending on how many investors you have and where they're from, it could really affect the price of this whole process, right?
Yes, that's the biggest variable.
So we've got a property under contract. We've started our PPM. We've determined which filing we're going to pursue. We've set up our Delaware entity, filed our Form D. Is there anything else?
That's it.
Okay. And how much of this process is your attorney taking care of?
I'm taking care of forming the Delaware LLC, writing the operating agreement, writing the private placement memorandum, writing the subscription agreement, and filing the Form D.
Pretty much all of it.
Right, all the securities and business end. The local real estate attorney is handling the purchase and sale contract, the deed of trust, and the basic real estate closing.
And how long does this process take?
It takes me 3 weeks to produce the initial draft and maybe another 10 days to 2 weeks to finalize everything. So you're looking at maximum 5 weeks. Maybe I've done it in a little less than 4.
Wow, that's pretty quick. It's a lot quicker than you would think for all of the forms and filings.
Well, when you've done it for 26 years, it gets to be pretty routine.
Good. So, Stephen, from your experience, what are things that trip people up? Maybe things that real estate syndicators didn't see coming?
Thinking something is not a security when it is. That's the biggest trip up.
Could you elaborate on that?
The definition of a security, at least under the Supreme Court case of W.E. Howey and Company, and most states follow the Howey test, is an investment of money in a common enterprise with the expectation of a profit to be derived in whole or in substantial part from the efforts of others. And obviously, we always have investment of money in a common enterprise with the expectation of a profit, or no one will give you a check. The question is the issue of control and who's exercising the effort. If a managing member is in charge of buying the property, selling the property, leasing the property, mortgaging the property, hiring the attorneys, hiring the paving company, hiring the contractors, any of those, then you got a security. The investor lacks day-to-day control over the operations, then you're looking at a security. And 99% of the time, investors lack day-to-day control over the operations.
Right. So while they have maybe voting rights in the LLC, if they lack day-to-day control, it's still considered security.
Voting rights is not control because, as I say, I own shares of publicly traded companies. I have 1/1 billionth of a vote, maybe.
Right.
I have no more control than anything. If vote constituted control, none of the companies on the New York Stock Exchange would be securities, and there'd be no securities law. I mean, that would be insane.
Right. Okay. That's a good way to put it. Okay. So sometimes people mistake what a security actually is. Is there anything else that people get tripped up on?
That's the biggest bugaboo.
Okay.
That and maybe accepting money before PPM has been given.
Right.
Just because someone gives you a verbal commit, that's okay, but you can't go beyond a verbal commit without giving a PPM. Those are the two biggest bugaboos. The third one is just a general lack of communication, not telling the attorney in which states all of your investors are in. And then all of a sudden you're looking at missing a 15-day filing deadline in that state. And the state ordering a return of that investor's money in those states. I mean, the third one, it can simply be addressed with good communication. Okay. These are the states where my investors are located, and if I got to change, I'll let you know immediately.
Okay, so this process typically takes maximum 5 weeks, and along that period, your investors are going to be mailing in checks, but they're not mailing them into the real estate syndicator. They're mailing them into who exactly?
Actually, they could. once you get a PPM, then checks can be mailed. Once the investors received a PPM, they can be mailed to the syndicator.
Okay.
Checks can, by all means, be mailed to the syndicator.
Okay, got it. All right, Steve. So we've kind of walked through the process. Is there anything else that you think is worth mentioning, or anything out there that our audience could learn from throughout this process?
That is a critical factor. I think the most important thing is when they're looking at a property, get the year constructed, look for properties built after 1978, because that way I don't have to put lead-based paint or asbestos as risk factors in the risk factors section of the prospectus. That eliminates two big risk factors right away. Get details as to the repairs. What repairs are expected? When was the last time repairs were done? What's the overall condition of the property? What's the vacancy rate? What's the vacancy rate in the area? What's the rent? What is the rental rate? What's the split of the property? How many 1 bedrooms? How many 2 bedrooms? How many 3 bedrooms? The length of the lease terms. When somebody vacates, do you plan on renovating the apartment and raising the rent? Your overall strategy. It's very important to have an overall strategy going in. That's probably the biggest takeaway.
Okay, right. So it sounds like the more details, the better, especially when it comes to details of repairs, condition of the property, market rents, things like that. The more information you can disclose to investors, the better protected you are.
And as well on the mortgage end, what's the amount of the mortgage? What's the term of the mortgage? Is there any prepayment penalties? Are you planning to refinance after year 5 or year 8 or year 10? What's the exit strategy? That kind of thing.
Right. Okay. Well, that's certainly helpful, Stephen. I know when I was first starting out that this all seemed like a foreign concept to me, and to be able to break it down from somebody with your experience is certainly helpful, and it's a step that I didn't realize was necessary until after I had initially had my first property under contract, and then I was already behind the 8 ball, so, it's certainly good to know this information ahead of time.
Absolutely.
All right, Stephen. Well, we certainly appreciate your time today. Is there anything else you'd like to leave with our listeners, or any last words?
No, I look forward to working with them on their ventures, and it's an excellent process. The process has worked many times over, and through syndications, a lot of people have been able to get into the multifamily game.
Right, absolutely. All right, Stephen, so wrapping up, where can our listeners contact you?
Okay, I can be reached my email at stevendrinaldi@msn.com. My phone number is 240-481-2706.
All right, great. We'll put that contact information in the show notes for our guests to get a hold of you if they need you.
Great. Thank you very much, and I look forward to working with everybody.
All right. Thank you, Stephen.
Thanks a lot. Have a great day, everybody.
All right, that wraps up our episode today with Stephen Rinaldi. Stephen is a great source of information and has a ton of experience putting together private offerings of securities for real estate syndications. You too can make Stephen a member of your own team. If you're getting value out of this show, please let me know by leaving a rating and review in iTunes. Please subscribe to the show to be notified of new episodes. You can now find the show in iTunes, Google Play, Stitcher, Spreaker, and TuneIn Radio. As always, if you have any questions or comments or just want to drop me a line, feel free to do so. You can reach me at info@jacobayers.com or www.jacobayers.com. Till next week, signing off, I'm your host, Jacob Ayers.
You've been listening to the Real Estate Way to Wealth and Freedom podcast, providing you actionable content to build your real estate empire. Nothing on this show should be considered specific, personal, or professional advice. Please consult an appropriate tax, legal, real estate, financial, or business professional for personal advice. The opinions of guests are their own. Information is not guaranteed. All investment strategies have a potential for profit or loss. The host is operating on behalf of the Real Estate Way to Wealth and Freedom, LLC, exclusively.